seated. All right. We are on the record in 4 matters at this time: 23 CV 23357, 23 CV 44337, 23 CV 44338, and 23 CV 24710. Mr. Thompson, good afternoon.
Good afternoon, Your Honor.
You are plaintiff in all 4 matters. And Mr. Reinecke, good afternoon.
Good afternoon, Your Honor.
And you are representing defendants in all 4 matters, correct?
That is correct. And since there wasn't enough room up here, if it's okay, they're all here in person, but they are in the gallery.
All right, thank you. Good afternoon to each of you. All right, it's the court's intent that we take up the motion to consolidate first. Depending on how the court rules, that will direct next steps. Ultimately, what I'd like to get out of this hearing is somewhat of a scheduling conference so that we can take time to schedule motion dates to hear the motions that have been filed that have not yet been heard by the court, and if the parties agree, set trial so that we are able to move these matters forward. So that's the court's intent. Mr. Thompson, any problem with proceeding that way?
No, I guess I'm a little concerned about having these all lumped together because of the fact that they are individual cases.
Well, that's the motion to consolidate. So we're going to hear that first, and then I will rule. I will either grant the motion to consolidate or I will deny it. And then depending on my ruling, I'm going to set dates in the future to hear the motions that have been filed in each case and hopefully set trial dates. All right. So I'd like to use the time we have today to address not only the motion to consolidate, but also to schedule future dates.
I understand.
All right.
I like it.
All right. Mr. Reinecke, any problem with proceeding in that fashion?
No, Your Honor, that's fine.
All right. That's how we'll move forward today. And Mr. Reinecke, we are here on your motion to consolidate, so I will hear argument from you first.
Thank you, Your Honor. The 4 lawsuits Mr. Thompson filed against Reed family members primarily rely on ORS 30.845, which is a 2019 statute that the legislature created to prevent people from calling the police against people who weren't doing anything wrong and just calling to harass them. Here we have a different situation. There's this disagreement about who can use this easement, who can use this area. Mr. Thompson says, it's my easement, you don't have an easement. We say, you're right, we don't have an easement. We own the underlying property. The court has repeatedly stated that there is a it is a non-exclusive easement such that both parties can use it. In fact, Deschutes County authorized the Reeds to use the same driveway as their driveway. The Thompsons didn't like that. They appealed that to the Court of Appeals through LUBA and the Court of Appeals, and they lost. But we're where we are today. And so there's this call. There's also the claims of intimidation and also intentional infliction of emotional distress and defamation. So the reason why we filed this motion is we thought it made sense under ORCP 53, which basically says if there's common questions of law or fact and that it would avoid unnecessary costs or delay, that it would make sense to consolidate cases. I understand Mr. Thompson's comments that it's not exactly the same cases, but it is the same law that's applying. It is the same situation that's applying. It is the same motivations that the Reeds are contacting law enforcement for. Whether the motivation is purely to in violation of the statute, ORS 30.845, or whether they're calling because they believe he's interfering with their rights to use their property. It's the motivation, and the motivations are effectively the same. It's going to be the same argument from both sides. So it seemed to us that it made more sense. We don't see any prejudice, although Mr. Thompson has said in his response that he objects. He hasn't said how it would be prejudicial. On the contrary, he basically says that by defendants doing this, they would they are compromising their own case, and that somehow.
Excuse me, Your Honor, if I might interrupt. I would prefer to make my own comments on my own motions and case. I don't need Mr. Reinicke here to try and speak for me.
Understood, sir, and you'll have opportunity to do that, but you filed a response, and Mr. Reinicke is free to interpret that response. If you disagree with his interpretation, I expect you'll tell me.
Thank you.
So specifically, the questions of law, it's property rights, the exclusivity of the easement. It's indirect in that it is an issue in the case in terms of their motivation as to why are they doing what they're doing, why are they calling law enforcement. There's constitutionality issues. We're not asking that a hearing be set on it yet, but we are filing motions for summary judgment before the end of this week on constitutionality issues. If those pretrial motions are denied, we will be raising those issues again at trial. There was a temporary restraining order issued in the 2021 civil case. That case became a preliminary injunction. The things that Mr. Thompson said and did are exactly what the court told him not to do in those. Now, there is questions now because that case has been dismissed and it is on appeal still. But for the motivations for the Reeds, clearly that's in their mind that the court has said, hey, you can't do this. And that's exactly what he did. And he even says, I'm doing exactly what the court told him not to do. So we believe that those things are important. On defamation, it's the truthfulness of the defenses and the statements are the same. Yes, when you call law enforcement and you say, hey, somebody's interfering with my use of my driveway, you might not use the same words, but it's the same issue, that this person is asserting that I don't have a right to use this. So not only are they interfering with my right to use it, but they're telling me that I can't use it, which is again is in direct violation of the court's previous temporary restraining order and preliminary injunction. And then there's the issue of simply calling law enforcement. You're calling law enforcement because there's a bad situation. There's an impasse. I'm blocking your entrance and exit on what you believe is your property, whether Mr. Thompson believes that's true or not. That's the fact, that they believe they're on their property, and he's telling them, you can't be on my property. This isn't your property. Only I have this easement. So it's exactly the same privileges in contacting law enforcement. Those are the questions of law. The questions of fact that I think are similar, which I kind of commented on already, is that in every single case, Mr. Thompson confronted the person trying to use the driveway. He came out, went out of his way. They didn't go to him. He comes to them and he says, get off my property, stay away. This is my property. It's my easement. Get out of here. You can't use it. And he interferes with their use. He parks his vehicle in front of the gate so that they can't drive through or open and close their gate. He yells at the Reeds and their guests and tells them that they don't have any right to be on the shared driveway. That's the same in every single case. And so to secure the use of the driveway, the Reeds, and to avoid any escalation of this impasse, they called law enforcement for assistance. So those questions are the same in each case, even though they're slightly different. So the factual question, again, I said motivation. Were the Reeds calls to law enforcement for legitimate reasons rather than those under ORS 30.845? The issue is their motivation. The facts of each case are the same with respect to what are the motivations for why they're doing what they're doing. So it seems like it would be duplicative and unnecessarily delay and cause costs if the cases were handled separately. Finally, I would just say in presentation of Mr. Thompson's evidence, I want to speak for him, but he did allege infliction of emotional distress. That requires that you show evidence that you have been severely emotionally distress caused. You have to assume that that can't be limited to the proof of that is not going to be different in each case. It has to be the same. He's going to have to put on evidence of what it is, what harm it has caused him, what severe emotional abuse that has caused him. And that's going to overlap substantially. It's not going to be, there'll be differences, but not really. And that's all I have unless the court has questions for me.
All right, thank you. Mr. Thompson?
Thank you, Your Honor. As is typical with Mr. Reineke and with his clients, virtually every word that comes out of them is a lie, as we've just heard here. To start, the first thing I'd like to address here is this. I hardly heard him say anything about the motion to consolidate, but why is he coming up with a motion to consolidate at this point in time? We have cases that were filed over a year ago, and now all of a sudden we want to consolidate? That tells me one thing, and one thing only, that he knows that he can't win any of these cases on his own because they're all rubbish from the defendant's point of view. So he talks about, preventing things. The court repeatedly saying it's non-exclusive, but no court here or anywhere else has ever made a determination that our easement is non-exclusive. It was created exclusive, and there's nothing that can change it. This easement was created over 50 years ago.
Let me stop you right there. Do you think that that's going to be something that's argued about in each of these cases?
Pardon me?
Is that issue, the issue of the easement and who can use it and who can't, is that going to be at issue in each of these 4 lawsuits?
Well, Mr. Reineke seems to think it is. I don't think it is because it was defined that way. There's been no contract or agreement to change the non-exclusivity of this. It's never been a matter that's been brought up in court to be adjudicated at all, ever. So how does that happen? It is unfounded that this thing can be called non-exclusive. And what does non-exclusive even mean? Does it mean anybody can use it? Is it a public road? Whose is it?
Mr. Thompson, my question to you is, are those arguments that you're going to be making in each of these 4 cases?
Yes.
All right.
Yeah,
Thank you.
because, it's just a statement of fact. It's not really an argument. Okay. Then the timing of this motion is, to me, quite absurd. Why now? If this was, and if you remember back to the beginning, I filed this lawsuit. I named all of them in it. Mr. Reineke wanted them all dismissed and separated out from it, with leaving just Casey Reed. So in the initial instance there, that was a de facto 53B separation. Only they didn't really think that I would sue the rest of them, but they still turned right around and did the exact same thing that Casey Reed did. Even after they knew about this law and they had legal advice to advise them on that, they turn around and do the same thing. Another thing that they do have in common, as I've already stated, is that they all lied. In every single issue that's the basis for these complaints, they lied. They made comments to police, it's all in the records, that I was blocking the road when I wasn't. I have not ever blocked this road, ever. I've made it known that it's my road and they're not welcome to use it. I even went so far as to issue them a cost of what I was going to charge them to use it, $2,500 a day. Well, they just used it more, so I doubled it to $5,000 a day. They still use it every day. It's my road, it's not theirs. It's that simple. The question about exclusivity is just bizarre to me, because in the time since it was created in 1971, the matter of exclusivity has never even come up, but the writing of the deed makes very clear that it's exclusive. Nobody else has that piece of property, the rights to it. And the Supreme Court has ruled many times that an exclusive easement is essentially the same thing as simple owned property. And yet we have to run a gauntlet every time we have to use our easement. We don't have any other way to get to our home, to our property. They don't have to use the easement. They had another road to use. This whole fiasco with the house building in Luba, everything was done strictly for the purpose of interfering with our easement. They built this house 30 feet from the edge of our easement. 30 feet. Who's going to go way out in the woods somewhere and build a house that close to somebody else's road? Nobody in their right mind would do that. It was all done for the express purpose to harass us, drive us off of our property, and try and take possession of it. And Mr. Reineke's been on board with that. He's made a killing off of these Reeds paying him money. They think they're going to pay him legal fees and end up owning our property. It's not going to happen. So that's the game that's been going on here for a long time. The Reeds used to tell other people that they owned our property. People didn't know. When I met people out there, I actually circulated a petition in the area. People would say, "Who are you?" Well, I don't know. Where? Well, you know, he doesn't. I live over here. Well, we thought the Reeds owned that. I said, "No, they've never owned that. My uncle owned all of it and sold off pieces." So anyway, so the whole thing, you know, and here we go. We have filed judicial notice of the deeds. The deeds say it all. It's that simple. It's like 3 pieces of paper. And if anybody could read and understand and enforce those, none of us would be here. So to get back to this consolidation, we're talking about fully grown adults doing their own things. And it makes, for the purposes of this, it really makes no difference whether it's exclusive, non-exclusive, whose it is. All these summonings of police were based on lies saying that I was blocking a road. And you will see no evidence that I ever blocked anybody on my own road that I own, or any other road.
Mr.
So-
Thompson, how are you prejudiced? And do you understand what I mean when I use that word? How are you harmed, or how are you put at a disadvantage if I were to grant this motion, if these cases were consolidated?
Well, it wouldn't give a jury a fair chance at all. I mean, just for as simple as an issue as it seems, there's a dog breakfast of stuff going on. And to lump this all together and, you know, present that to a jury, it would be absolutely impossible. They couldn't understand that. What's this and that? And these people have done individual acts that need to be treated in an individual way, and they need to be held responsible for what they've done. And if somehow it was all lumped together, it would change the character of these lawsuits, and it would reveal that it's all a conspiracy, a big conspiracy, and that's a big deal.
What,
And that-
explain that to me. I don't follow.
Well, for one thing, people doing this kind of thing in a conspiratorial manner is a crime, and it should rightfully be heard by a grand jury. So the idea of someone harassing somebody else with the hopes of gaining their land by one person is one thing. But when you have a bunch of people brought into the picture here, I mean, the first thing that happened was Casey Charles Reed showed up at the end of our gate, coming and going all the time. He's there at the gate. He's going to open the gate, closing the gate. My wife had to quit her job in town because she couldn't handle it. Coming home at night in the dark and having some strange guy hanging around the gate and harassing her. How's that okay? So that's Casey Reed. So each of these people also has an individual history that's going to have to be developed and brought in. Talking about the motivation of why are they? Why was Casey Reed even here? Why was he involved in any of this? That's a big project in itself. I mean, I know why. He came here to help with the cause of getting us out and getting our property. See, the Reeds control a piece of property. We happen to have this road that goes through the middle of it and a chunk of it in there that includes 3/4 of a mile of river. Well, they just can't stand the thought of, they envision this holdings of this chunk of land, but somebody's got to drive through it. And they just hate that. They sit across the river and look out their front windows and they see cars come and go, and they just become infuriated beyond control. And they call Mark Reineke and offer him money to do something about this. Well, it was all done when the deeds were written. The deed for our property, including the easement, was granted in 1971. That deed existed on its own until 1988, when the Serbian piece of property was granted and deeded and clearly shows the easement and who owns the easement on that deed. So it's not like anything all happened at the same time, or it's not like an easement that goes back through 50 different ownership changes in land. This is the same one that's always been there. And so it's really simple and straightforward. I have hundreds of pages of AmJur on easements, and there's nothing in it that does not concur with my position. I've read Supreme Court decisions, and they all are the same thing. You can't interfere with somebody's easement. We have a constitutional right to enjoy our property. Nobody can interfere with that. No normal person would want to. So here we have this thing where we are literally harassed and interfered with every day. People who come to do business or friends are harassed so that they're scared to even come onto our driveway. And they shouldn't be. This easement, when it was put into effect in early 90s, was fenced on both sides so that none of this kind of stuff could happen. Well, it'll be 12 years tomorrow that my father passed away after my mother and my twin sister. And the Reeds had to realize that I was not going to sell them this piece of property. So they've declared war in every dirty, dishonest way possible by abusing the judicial system. Since then, that'll be 12 years tomorrow. So back to the consolidation. Each of these things have to be treated separately. I don't see how you could do that if they're all consolidated. I mean, yeah, Mr. Reineke might write all the same admissions answers where he does nothing in those except repeatedly call it a shared driveway. It's not a shared driveway. You can't have a shared driveway without people agreeing or contracting to share it. The easement law says that if there's more than one easement holder, there must be an easement maintenance agreement. There's no maintenance agreement. In fact, I do all the maintenance. I plow all the snow, and then what? I plow it for them to use? No, not when they're harassing me and everybody else that comes around. So there are big issues with what's gone on here, and Mr. Reineke has engineered this to where it puts people in conflict where there shouldn't be a conflict. People should be allowed to come and go to their own property, and there's a very big mega bomb that's buried in the middle of this that I have not disclosed, but that the Reeds are very much aware of, that is a totally terrible tool to try to use for something. I'll share that right now. We have an easement for roadway purposes, it's called. And they were all written that way to accommodate whatever need was required for that roadway. And that involved ditching, all kinds of things. The big thing it involved, even in those days, because they weren't aware of fiber optic cable, all that kind of stuff, was power. So the Reeds have engineered this thing with Mr. Reineke's help, where they fully would intend to deny us putting power into our property on our easement, which is one of the roadway purposes it was made for. And the reason that we have never done that, by the way, is there was the biggest ponderosa tree right in the center of our easement. And we didn't want to disturb that tree. So we digging a trench, cutting its limbs, all those kind of things. If you're going in the air, those are your two choices. We preferred to enjoy that tree. Well, that tree's gone now. Someone else got rid of it, who had no right to do so, had no right to be on that easement, who did unbelievable amount of damaging work. So getting back, we have separate incidents. It wasn't all the same incident. When you're consolidating cases, we read a bunch of stuff on consolidation. It is typically something that is done with one defendant who has done multiple actions. Well, that's not the case here. We have full-grown adults doing their own individual thing because it's something they can do. And here's another big side effect of that. They summon these police. The police won't come anymore. We still, if I have to encounter someone on my road, I tell them what I think. They threaten to call the police, but they don't because the sheriffs would not come. It's like the little boy calling wolf. One of the big reasons for that is that we have a large lawsuit against the sheriff's office in federal court. And I don't think that's going to work out well for the sheriff's office and the people of Deschutes County who end up paying the bill for that stuff. I mean, the sheriffs have enough lawsuits going on in their office, but this is a little beyond that. And it's telling that when the sheriffs have all these problems internally, it doesn't stay internal. It spills out into things. So these people somehow were persuaded by the Reeds all in on this thing to think that, the Reeds were right, and this is the Reeds road and everything, and which in the Reeds' mind it has for a long time, has been, but that's the only place in their mind. So, they managed to recruit these sheriffs to come in and get behind the thing and make all kinds of problems. We've had, you would think that there was a sheriff's office in our driveway, a lot. And people driving by all the time, they're going, oh, what's going on in here? There must be a big drug lab or something, and that's the kind of thing. And the Reeds just eat that stuff up. They love having sheriffs come around there. And we have all the phone calls. You hear what they say. It's absolutely absurd. It's absolutely, and it's all lies, which, my understanding, that's a crime too, lying to law enforcement. They do it routinely. They'll do it every day. They'll do it tomorrow. So ultimately, with this, they each have their own story to tell and their own actions to defend. And I see it only becoming a lot more confusing for everyone if this were to be consolidated, which I don't think it is. I don't think there are proper grounds for consolidation of these cases into one. They can be nice little single cases. I mean, we have a hard time getting any kind of discovery out of Mr. Reinecke anyway. So to try and lump that all, how's that going to work? Very difficult and very, very compromising to the judicial system. So I obviously don't think they should be consolidated.
Understood, Mr. Thompson. The court has to consider whether either party would be prejudiced by the consolidation. Court also has to consider, in addition to whether there's or in conjunction with the question, whether there are common issues or questions of law and fact, is judicial efficiency. And would it be more efficient for the court to try these to one trier of fact than to have 4 separate proceedings? And so do you want to address that?
I agree with that, and I've thought about that, and it would be absolutely way less efficient for the court to try and lump this thing. We'd be, compelling discovery and doing things till the cows come home. And so it could never come about because each person has their own reason for being there, separate. They're not all there for the same reasons. So the fact set is different. Their lies are different. I mean, it's basically the same lie, but in each instance, there also are a whole different set of witnesses for each one. And so to try and lump that all together would be an absolute dog's breakfast. So we have law enforcement witnesses for each case. And, sorting all that out, most of the time it's different ones. So I don't see really any way to consolidate them, and it certainly wouldn't be more efficient.
Thank you. Mr. Reinecke, response?
Normally, Your Honor, I would say no. I'm just going to say that I love the system of justice in this country, and it is a shame that this man can make a mockery of it. And this man can do what he does to these people on a daily basis. I have nothing else to say.
I believe those comments should be struck, Your Honor. That was way out of hand and completely irresponsible.
Thank you. You both have made your record. All right. As the court reviews as an initial matter the pleadings and the complaints that have been brought in these 4 actions, The court notes that each of these 4 actions have brought a complaint under 30.845. 3 of the 4 actions have brought a claim under 31.210, and 2 have brought a claim under 30.198. In summary, many of these claims overlap in each of these 4 matters that are at issue for the court today. As Mr. Reinecke has outlined for the court, there are significant common questions of law that are going to apply across the board as the court considers that instructs on the law that will apply as this case moves forward. And so those common questions of law are significant across these cases. The court also, having presided over a number of these, the issues involved in this case, understands that it would be difficult to have a trial in which other allegations were not brought in, which was an issue that Mr. Reinecke raised. That I think, Mr. Thompson, there could be down the road an issue where you want to talk about Mr. Casey Reed, but in doing so, you need to talk about Mr. Robert Reed, and I'm just using names from the defendants. I'm not using specific factual instances. And likewise, I could see the defendants wanting to bring in examples of other interactions that could explain or give context. So the court finds that these lawsuits are interrelated to a significant degree, and that it does promote judicial economy to have these 4 cases consolidated for the purposes of trial. So the motion to consolidate, and I said for the purposes of trial, they will be consolidated from this point forward. So the motion to consolidate is granted in all 4 cases. All right, so understanding that, I would like to take up scheduling, as I had indicated we would do. One moment, I have a list of motions we need to schedule. I've just misplaced it for the moment. All right, and consistent with the court's order to consolidate these, a number of these motions are going to be duplicative across the cases. For instance, at least 2 or 3 of these matters have a plaintiff's motion for judicial notice of undisputable facts filed. So that is, like I said, consistent with the court's ruling to consolidate. Before we take up the motion hearing, Mr. Thompson, do you believe these cases can be set for trial this time? And I'm not saying tomorrow. It would probably be a ways down the road, but can we get a trial date on the docket?
Well, I guess we'd have to look at what kind of dates we'd be talking about, and we'd be nice if we could get some indication of cooperation in discovery from these people.
All right. Mr. Reinecke, from your perspective, can we set these cases for trial at this time?
Yes, and we'd prefer to set them for trial as soon as possible.
All right. And Mr. Reinecke, how many days do you believe for trial is going to, how many days are going to be necessary?
Seems like it should be a day or 2, but I think we should set it for 4.
Mr. Thompson, do you think 4 days is going to be sufficient?
I would be shocked if it could be done in 4 days. Again, it depends on what kind of evidence we're allowed to gather through discovery.
Okay. Let me look at my trial schedule.
I mean, you look now from when we filed these things and Crick County came back. Look at all the time that has been wasted. Huge amount of time.
Let me see, one moment, please. What is, let me see. All right, I could offer a 4-day trial, October 15th or October 22nd.
That's way too early, Your Honor. I can't see this happening before the end of the year. You know, as you know, we already have another matter with Mike Shields on Pine Equipment, who just happens to be Kim Reed's cousin, you know.
Has that matter been set for trial? I don't recall.
No, that was suggested, but we haven't heard anything. That was suggested by the opposition.
Okay.
It seems quite apparent, Your Honor, that these various attorneys are doing a lot of table talk with each other, which is also quite inappropriate, but I'm sure that goes on, but, you know.
March 11th.
I can go with March 11th. It'll probably take that time. I don't know if we can get the discovery done by then either, but we'll go with what we've got.
Unfortunately, given the court's trial availability, it's October or March.
That's fine, Mike, thank you.
All right. We will set this for a 4-day trial on my docket, Madam Clerk, March 11th. All 4 of the matters will be consolidated for that proceeding. We will have trial readiness. That can be on the normal trial readiness docket. Madam Clerk, would that be on March 4th at 8:50 or 9:30? What time would that be?
It would be at 8:30.
At 8:30 for a civil?
Oh, I'm sorry, it's civil.
At 8 o'clock? March 4th? All right, trial readiness is March 4th. Oh, 8:15. All right, trial March 11th. All right, I'd like to schedule an omnibus hearing date to take up the motions that have been scheduled to this point and any that are scheduled between now and our motion date. That's going to be sooner than later so that we can make sure discovery is proceeding as it should, given the concerns Mr. Thompson has articulated. Mr. Thompson, when would you like us to begin looking for a date? What month to have a hearing on the motions that have been scheduled and any outstanding discovery issues?
Well, that could happen relatively soon.
Mr. Reinecke?
Sure. Yeah, that's fine.
All right, one moment, please. Mr. Reinecke, how long do you think we'll need for the motion hearing?
I'm not quite sure which motions, how many motions we're talking about. It's gotten a little bit away lately.
It has. Let me summarize the motions that I see are outstanding, and then maybe the parties can give me some guidance. In 23 CV 23357, there's the plaintiff's motion for an order to compel discovery. Plaintiff's motion to strike defendant Casey Reed's affirmative defenses and counterclaims. Plaintiff's objection to same attorney representing family members in separate actions. A plaintiff's motion to strike defendant's response to the objection to same attorney. Plaintiff's motion for an order to strike defendant's response to plaintiff's first request for production of documents. I have a summary in front of me, so I apologize if some of the captions aren't exactly correct. Plaintiff's motion to determine sufficiency of defendant Casey Charles Reed's response to plaintiff's request for admissions. Plaintiff's motion for judicial notice of undisputable facts. Moving to 23 CV 44337, there's a plaintiff's motion to strike defendant Karen R. Reed's affirmative defenses and counterclaims. Plaintiff's motion to determine sufficiency of defendant Karen R. Reed's responsive to plaintiff's request for an admissions, and plaintiff's motion for judicial notice of undisputable facts. In 23 CV 44338, there's a plaintiff's motion to strike defendant Karen R. Reed's affirmative defenses and counterclaim. Plaintiff's motion to determine sufficiency of defendants Donna Reed and Robert H. Reed's response to plaintiff's request for admissions, and plaintiff's motion for judicial notice of undisputable facts. 23 CV 24710, plaintiff's motion to strike defendant Robert Kim Reed's affirmative defenses and counterclaim. Plaintiff's motion to determine sufficiency of defendant Robert Kim Reed's response to plaintiff's request for admissions, and plaintiff's motion for judicial notice of undisputable facts. Those are the motions that the court has noted have not had hearing where one was requested. That's a significant number of motions. However, there, as I've already noted, appears to be quite a bit of overlap in the legal issues surrounding those motions. So with that, Mr. Reinecke, do we need a full day?
Yes, and I know that the court doesn't ever want to schedule anything for a motion that isn't scheduled, filed yet. But I just did want to remind the court what I mentioned earlier, just that we will be filing motions for summary judgment in these matters by the end of the week, but maybe we want to not deal with that right now since they're not filed. But I did want to let that go. Other than that, the ones that are there, I'd probably schedule it for a day and hopefully we get done in 2 or 3 hours.
All right. So what I'd like to do then is let's schedule this outside of the, with sufficient time for the summary judgment response and reply. And so that then we can have those heard on our day that we take up with the court. It's difficult for this court to have an entire day put aside for motions. And so that's a significant docketing restraint. So we will take up all the motions that we're able on that date. So if, let's see. It seems then, Mr. Reinecke, we should go to October so that the summary judgment motion can be filed with the applicable rules relating to response and reply.
On the motion for summary judgment?
Yeah.
If we could do November, that'd be great.
November?
Yeah.
All right, so let's see if I can find one day in November for all of these motions, and that's still well enough in advance of trial in March for moving forward. Let's see if the court can accommodate that. Oh, November's difficult for me, Mr. Reinecke. It looks like I can offer, well, let's see here. October 28th, November 1st, or December 3rd.
Any of those dates work for me except December 3rd.
All right. Mr. Thompson, do you have a preference on October 28th or November 1st?
The earlier the better for me, October 28th, I would pick.
All right. Madam Clerk, can I do that? All right. We will set this for a one-day omnibus hearing, October 28th, to begin at 9 a.m. The court will intend to hear the motions that I've articulated. Those will be added onto your notice of hearing, so you don't have to remember what I've said. You'll be able to reference them. The court will intend on adding the motions for summary judgment on to that date, assuming they are timely received to the court. And if there are other motions that come in, if I've reviewed and believe they can be heard, the parties will be given notice that they will be added on to that date as well, so that we are able to use our time efficiently and have all matters heard so we're ready for trial. I'm not going to do a trial readiness for that. I will assume the parties will be ready for October 28th at 9 a.m. omnibus hearing. Mr. Thompson, do you have any questions about that?
Not at the moment.
All right. Mr. Reinecke.
Just, Your Honor, at this point at least, it appears that the omnibus hearing is all non-evidentiary matters. Could my client's appearances, are they required on that?
No,
on that date?
they are not, unless it becomes an evidentiary hearing in some nation, well, let me say this, unless something changes between the parties, if subpoenas are issued or something changes. As it stands now, that it is not, their appearance is not required. Does that make sense?
Thank you. And then for trial call on March 4th at 8:15?
Same.
Same, thank you.
Mr. Thompson?
So will we be proceeding from this point back under the original CV, 23 CV 23357?
That seems to likely make sense. Mr. Reinecke, should that be the lead case? All consolidated to that?
Yes, I have no problem with that.
All right, and I think that, Mr. Thompson, likely the reason you asked is that everything can be filed into that case
Right.
without the need for duplicative filings.
That works for us.
All right, that will be the lead case. Thank you for raising that issue. All right, anything else before we adjourn this afternoon?
Not too much. Your Honor.
All right, those dates will be entered. I'll see the parties back October 28th at 9 a.m. for a motion hearing. Thank you.
Thank you.